All right, let's go ahead and start. Let's put phones away. So there's a reminder on the syllabus about the class attendance policy. I don't know, I put that on before. I saw who's in the room. I don't know how I knew that. Obviously the weather, sometimes it's hard to get to class. You all are here, so I'm not talking to you, but there might be some folks listening at home to the recorded lecture. The class attendance policy is detailed on today's handout. It's detailed on the syllabus, and folks should be aware of it. The next paper, which is a one-page paper, according to the syllabus, is due tomorrow, but I said on Tuesday that I'm pushing that back until Monday. So paper assignment 2A is due on Monday. Yeah. So with all the papers, please go ahead and upload them on Blackboard and give us a hard copy. Same rule as last time. It's on time if at least one of those formats arrives on time Monday by the end of business hours. So if you are not on campus on Monday, just make sure you upload it by 4:30-ish, and then bring me a hard copy on Tuesday is fine. But if you don't upload it on Monday, then it is not on time. So make sure one of them's on time, and make sure you get us both of them. And so that's due Monday. So I talked about it a little bit on Tuesday. The prompt is on the syllabus, so if you have not read that prompt yet, you should read the prompt. It is focused on the Warren Court. I'll go ahead and look at it with you quickly here. So it is on page, my page numbers are cut off, so I don't know what page this is. It's assignment number 2, 5-page paper in 2 parts. Answer the following questions. What were the key constitutional developments of the Warren Court era? So roughly all of the 1960s, plus the last half of the 50s are certainly included. And if there's some relevant stuff that bleeds into the early 70s a little bit that you want to talk about, that's fine too. During this, so what were the key constitutional developments? Why did these developments occur? Did they have a positive or negative impact on our Constitution? During this period, the Warren Court issued a whole string of landmark decisions across a wide range of legal questions, stepping back from the details of the individual cases. So you got to tell me some details about some individual cases, but also stepping back from those details, can you give us some overall theme that unites some of these developments together? Now, it doesn't have to unite everything. You don't have to talk about everything, right? But pick some different kinds of cases and come up with an argument about what was fundamentally going on during this period. What links these different things together, right? In class, we've been kind of moving through sort of one issue at a time, right? We talked about some stuff about civil rights. We talked about some stuff about free speech. We talked about some stuff about voting rights. We talked about some stuff about religious freedom. Is there some kind of theme that links some of those different specific things together, right, that can make sense of the Warren Court era as a whole? What was the court doing during this period, and why? That's the goal of the paper. The first part of that is just one page, an initial attempt to come up with a theme, right? Here's what I think was going on, right? Put that in a paragraph, and then on the bottom, rest of the page, here's another paragraph with some initial thoughts about some examples that I think could help illustrate this theme, right? Which could presumably include some examples from stuff that we've already read and talked about. But if you want to look ahead and find some additional examples, that's good too, right? I haven't read the criminal procedure decisions as closely as the stuff that we've already covered in the syllabus, but I also plan to look at those decisions, and I think they would fit this theme that I've articulated. You can put something like that in there. Yeah.
What pages from the book do you apply to this?
What pages from the book? Everything we've read so far, plus everything up through February 20th on the syllabus. Right, so some of that stuff obviously we haven't read yet, but the pages are on the syllabus and you are welcome to go ahead and look at them. I don't expect you to read all of the material from now through February 20th by Monday, But you could flip through it and see what's in there, right? And the syllabus itself kind of tells you what's in there because there's topics listed on the syllabus and the like. So everything up through February 20th is basically covering the Warren Court era, loosely defined. Like we have talked about some cases from the 1970s. There's a case from like the 1990s that I'm going to mention today because it's relevant to something I'm talking about. But in general, what we've been talking about so far is the 1950s and 60s. Right? Earl Warren was Chief Justice from late 1953 through 1969. The era is named after him. Is that a thing? Like, why is this an era in the court's history? What distinguishes it from what it was doing before or later? Right? Give us some kind of account of the Warren Court era of our constitutional history. So the first part is just one page. Initial, we're not expecting you to have it all perfectly worked out. The goal is you've got to come up with something. You got to come up with something, right, and get it on paper, and then we give you some feedback. If you don't come up with a good plausible theme, then we will tell you. If you come up with a good plausible theme, but you don't come up with any good examples that seem to fit with it, we will tell you that. If you come up with a good plausible theme and some good examples that seem like they fit with it, then we'll tell you that. And then you have some feedback before you write the rest of the paper. Questions about that? Okay, single page. I'm not really like a stickler on page, like with the last paper. Lots of people ask, is it okay if I go a little bit over 3 pages? The answer to that is usually yes. But if it's a 1-page assignment, right, 1 page, try to stick with 1. Right, this is supposed to be a 1-page. If you print it, it should fit on 1 sheet of paper. If it goes a little bit over, print it double-sided if you can. Right, a single sheet of paper. Okay, and I have office hours right after class today, if anybody has questions about anything. All right, we're going to start with some small group discussion this morning. So why don't you go ahead and rotate your chairs, and then I will tell you what you're talking about. Groups of 4 or 5, whatever works.
Anywhere? I mean, this is sitting right here. Is that good? Or
turn a little further. You kind of slide in, but you're not rotating very much. There we go. That's good. Okay. So you guys are lawyers in Texas, present-day Texas, and some potential clients walk into the office, and here's what they say. They say, we are families with school-age children. Our kids go to school in the Edgewood Independent School District, which is in the San Antonio area. And it has come to our attention that the district is spending about $5,700 per pupil per year. $5,700 per pupil per year. And right next door, the neighboring district, the Alamo Heights School District, is spending about $7,100 per year. $7,100 per pupil per year. Our school district is poor and mostly Mexican American. Alamo Heights is wealthy, suburban, mostly Anglo, white. Do we got some kind of case here? Can you do something about this? Is there a constitutional challenge you can file for us? What do you got? Right? So your task, you're the lawyers, right? You're going to take the case, and if you are going to take the case, what kind of arguments are you going to make? Right? You got 10 minutes or something to come up with some constitutional arguments for these families. See what you can come up with and write something down.
That's fun.
Yeah.
That was a dissenting opinion?
I'd also say that it's not everything in the Constitution that have this equal right to education. Although it's argued for women that have protection based on their economic class, there isn't anything like a right that should be protected by
Implicitly, because they're all, they're anything in
Either way, this is
some of that money is going to the state or federal
like the nice group and then you become like a self-serving wealthy
what the decision there is that like if the state is unequally giving money, the state is making an arbitrary decision and giving them right. But if the different income tax generated just happens to have different houses that are currently there and could potentially change in the future, then it isn't this arbitrary decision. It's just the result of a matter of fact.
So that's my thing is kind of if the local taxes
Yeah, you definitely change the proportion.
So I would say an argument in favor of the candidate though is that the district is majority minority population, and there seems to be some sort of discrimination based on some sort of aspect, whether it be racial or class-based. Although it's not like ostensibly racist, it happens all over Texas, where and the black school districts just don't get enough money. So bring it in terms of race, but indirectly. Well, the injustice caused by racial discrimination, that would be the 14th Amendment case to be
Yeah.
right.
So that's like your son. Yeah. Right? So would that be? That's what I
Well, if people argue that the idea of income taxing itself is, of course, it's going to be an important kind of argument.
Didn't really solve anything that's going
Income
on.
tax that you're using to generate wealth for school districts plus the incomes of Hispanic and African Americans in lower these areas and African Americans and Hispanics who don't have the same education quality as the white counterparts. All of this is educated in some way. And I don't think it's any mistake that the school districts are drawn in a certain way, where one district is majority white and one district is majority minority. So, yeah, I think that actually, thinking about it, districts are so different in their composition. I don't know if it's entirely due to yeah. We don't know if they're like trying to gerrymander it, or if it's just the fact that the south side is poor, north side is rich, and that structure is too different.
So let me pause you for a second. So each group should make sure to write a couple things down, 2 or maybe 3 things down. 1, do these families have a case? Like, are you going to take this case in theory? Is there some kind of legal argument here that you might be able to make? If you can't come up with anything at all, you might just say, sorry, I'm not going to take the case, right? 1. 2, is there something specific additional information that you would want to know? I've given you some basic facts, but like, what else would you want to know? And 3, assuming you're going to take the case and you got whatever additional information you needed, what do you think is your single best constitutional argument? Right? We'll write down something concrete. What is if the judge only lets us make one argument? What's our best argument? Right? Something concrete there. All right, keep going. A few more minutes.
Sometimes in urban areas, so I'm not sure if that's
We can put that as like additional information we would need how they were distributed.
Is this what the?
Yes.
Oh,
Whether
okay.
it's really whether
Somebody asked. Okay.
I'll tell her.
Okay.
there is intentional separation of the different classes, different races. Racially motivated. Alright, so what's our like mark?
Alright, 1 minute. Make sure you got some stuff written down.
Do we want to say that we I still think so.
Not without better information on it.
Then yeah. It's pretty much all that. If you really want
Well, we were, but then it kind of slowed down.
yeah.
No. Okay. Pretty much where you were. Okay, so how did you answer?
I think it's more first of all,
All right, let's stop there. Let's turn back towards the front. Let's turn back towards the front. All right. So raise your hands if your group thinks there is a potential case here. Well, come on. Right? Nobody. Lawyers make money by taking on cases, not by not taking on cases. All right. Tell me. Raise your hand if you've got some extra information that you need before you're going to decide. All right. Yeah, way in the back. Yeah. I forget your name.
How far apart are the districts?
How far apart are they? They're neighboring. They touch each other. They are adjacent. Yeah.
And you want to know like how much like federal / state dollars are coming, like where the money from, where this money's coming from? Like is it coming from purely based on taxes, or is it coming from like federal grants, state grants?
Yeah. Well, it's all taxes, one way or the other. But schools are funded by a combination of local, state, and federal dollars. Historically, it was mostly local dollars, although over time, states and the federal government have started kicking in more. The state in general, state and federal spending is more equal than local spending, and so most of the disparity results in disparities in local spending, right? And so most of that results from the fact that local governments raise most of their money from property taxes, and in a suburban community where the property is more valuable than in a neighboring poorer or more urban community, the suburban community might even have lower property taxes, right, as a percentage, but it raises way more money, right, because the property's more valuable. So that's where most of the disparity comes from. Yeah.
How many kids are in each school?
I don't know. I mean, it's school districts, it's not schools, but this is the per pupil expenditure. So the number of kids doesn't really matter, right, because that's per pupil.
Well, it does kind of, because if you have less kids, you can make it go farther.
But that's per pupil. Right? It's the money divided by the number of kids. Right? Right? Yeah.
The big question our group had was, how are the borders of this district decided? Are they based on city, county? Are they arbitrary? Are they racially based? We need to know who decided and how the borders of the district were decided.
That's a good question, right? And so for Edgewater and Alamo Heights, I don't know the answer, but I can give you some general answers. So school districts are local, right, governmental organizations, and in many parts of the country, they are hyper-local, right, where there's like really tiny school districts. There's lots of school districts in this country that have a single school. And so part of it is just, part of the answer is just historically rooted local control of local government activities, right? So this is our town. We've always had a town council and a local school district, and we've always controlled our own school, and it's been separate from whatever communities are nearby. So that's just a historical legacy. Part of the story, however, is that suburban communities have intentionally cut themselves off from nearby urban school districts, right? Often as an explicit response to school integration. Right, so rather than, right, so once upon a time, pre-Brown versus Board of Education, and even for a while afterwards, right, within a single district, you had white schools and black schools, right, and so white kids were not going to school with black kids. As the courts and the federal government start to force those schools to integrate, right, one of the things that happens is that some white families leave the district, which sometimes just means moving, right? Oh, I used to live in the city and now I live in the suburbs, right? It sometimes means actually changing the boundaries of school districts, right? Forcing through a political change in the boundaries of the district. So I don't know if that's true in this case, but there are examples where it has happened. We have carved ourselves out of the LA County School District, right? And now we have our own separate, wealthier, whiter school district. So I don't know if that happened here, but that does sometimes happen. What else do you need to know? Yeah.
How does the Texas state constitution discuss education? Is it like the national constitution where it doesn't really say anything, or is it like Kentucky Constitution where it clearly states you can have equal schooling for everybody?
Oh, so this is good, right? This is good. So I was thinking, and when I gave you the prompt, I was thinking of federal constitutional arguments, right? But of course, the federal constitution, one thing, if you started looking through it, it would help if there was some kind of right to education in there, which there is not. Most state constitutions do have some degree of a right to education, including Texas. It's phrased in different ways in every one of them. Sometimes they say, everybody has a right to, a free and adequate education. Sometimes it says something like, the state government is obligated to provide a system of common schools for the population, right? So there's lots of different phrasings, but almost all of the state constitutions have something in it, compared to the federal constitution, which has nothing explicit. They usually have something in it explicitly about a right. The right of the people to some kind of education and or the obligation of the government to provide some kind of education. And sometimes it has a word in there like equal education or fair and adequate education or common education. I don't remember the exact wording in Texas, but there's often some adjectives in there like that. Is that a hand? It looks like a tentative hand. Anything else you need to know? This, by the way, so these are real numbers from these two real school districts in the 2011-2012 school year. These are real numbers from the exact same two school districts in the 1967-68 school year. Right, so there's a lot of inflation, right? So those numbers look small, but even if you account for inflation, we were still just spending a lot less on education in the 60s than we were later. But the disparity is long-standing. The disparity is worse here, right? That's 56%. It's gotten smaller, but the disparity's there and is long-standing, right? Okay, what's the best constitutional argument you can come up with? I've given you some additional facts. Now what do you got? You really want to help these folks out. We're going to give it a shot. What's the best argument? One argument on the table is right to education under the Texas state constitution, so that might work. What's the best federal constitutional argument you've got? Yeah, Nachman.
So the best argument that can be made is if the state is allocating the money in a fashion that's discriminatory, only if the state is doing it, then you could say that they are violating the 14th Amendment, which says they should have equal protection under the laws, and no state shall deprive any person of right to leave property. So the civil rights of certain individuals are being abridged by the state.
Okay, so that's a good argument. I got a follow-up question. So the language, one key set of words in the 14th Amendment is no state shall, right? It's a limitation on state governments. Legally, this is slightly convoluted, and just take my word for it. Legally, local governments are considered part of the state government, as far as the federal constitution is concerned. Federal constitution doesn't say anything about local government, but the federal courts treat local governments as essentially part of the state government. So legally, the 14th Amendment applies to local governments as well as states. So, follow-up question. You said only if the state is spending. Do you still say that? Now, what if the state's given equal amounts to every district, but the local governments are spending different amounts?
Well, I think if the local government is taking care of its local population, I don't think it would apply, because I think each local government would take care of its jurisdiction.
Okay.
Unless they're both overlapped in the same
Right.
local government.
Now we're gonna say they're separate. They're right next to each other, but in terms of the school district boundaries, they are two separate jurisdictions.
I think that position's right, and so I would kind of counter. My argument would be if you can provide some sort of information that shows me that the motivations behind the boundaries between these two districts does have some sort of racial motivation. And that would make it to where the local governments aren't necessarily just supporting their people. They're supporting a specifically constructed group of people that is that way because of some sort of racial discrepancy, and that would justify a 14th Amendment equal protection of the two different
Yep. So this is good, right? So building on Nachman's point, right? So one potentially relevant provision of the Constitution is the Equal Protection Clause of the 14th Amendment, which says states can't deny anyone equal protection of the laws. And so one way to think about this case is that it is a form of, like, indirect racial discrimination, right? It's not like there's a law that says Mexican kids got to go to this district and white kids got to go to this district. The state is not officially discriminating on the basis of race. It's not like there's a law that says the state will give X amount of dollars to every school district in the state that's majority white, right? There's nothing like that, right? It's not direct, explicit racial discrimination, but it might well be a form of racial discrimination. So one potential argument we have on the table is that this is a 14th Amendment equal protection issue, and it's really a race issue, right? Even if the state is not officially discriminated on the basis of race. We got a majority Mexican American district, we got a majority Anglo district. The state for decades has been spending more money. The state and local governments together, collectively, have for decades been spending more money on the Anglo district. Maybe that's unconstitutional racial discrimination. We'll talk a little bit more about that. Any other arguments that are going to help? Something different from that. I'm going to wait. Yeah.
I don't know if it's a thought or it's kind of a question.
Yeah.
So, since the local levels, like they bring in more taxes, like between the two, like
Yep.
one brings in more than the other.
Yep.
If they give the same percentage, like back into education from the amount they raise, then would it be equal? But like the one that makes more in taxes would just have more to give back in terms of percentage.
So that is in fact true. I mean, I don't know if they give the same percentage, but it is in fact true that one jurisdiction has more tax dollars than the other. So they can do other stuff better too. They probably got nicer public libraries too, right? Their streets might be cleaner, fewer broken street lights, They got more money for everything that the local government does. One of the main things local governments do is spend on the schools. So that's one of the most noticeable disparities. So your question is...
That wouldn't be technically unfair because it's...
Why not?
Because the local government isn't being, discriminatory in any way. They're just putting the money that they raised from the taxes in their district back into their district.
So Nachman said this too, right? You put that phone away, Nachman. From one angle, if a local government is just taking care of its own people, they're coming up, you get elected to the school board of Syracuse, your job is to help provide the best education for Syracuse students. If you get elected to the school board of JD, Janesville DeWitt, neighboring suburb, your job is to provide the best education you can for students in JD. So from one angle, we're not discriminating against anybody. We're not doing anything unfair. We are spending the resources that we have in our community on our schools. Is there a different angle on that? Yeah.
It's technically equal, but it's not equitable between the two communities, and the poor community, the gap will just continue to grow. If the richer community is continually pouring more money, even if it's the equal percentage, the disparity would still grow. So you couldn't really say that it's then equal.
Yeah. So remember what I said a second ago about how local governments are considered legally part of state governments? The reason for that is that local governments don't have any autonomous sovereignty. Under our Constitution, states have some autonomous degree of authority. The federal government's not allowed to make the states disappear. Right? That is not true for local governments. right? The state government, anytime it wants, could abolish any school district, abolish any city council, merge two neighboring jurisdictions to create greater efficiencies. State government can do that anytime it wants. Local governments do not exist. They don't have any autonomous authority of their own. So while it is true that the existing practice is for most education dollars to come from local property taxes, the state could change that tomorrow if it wanted, right? That is a choice made by the state. And instead, the state could collect taxes statewide and distribute them equitably throughout the state. And tomorrow, fix that. Does that make it sound any different?
So is there any state that could do, is there any states right now that do this type of, measures?
There are no states that have gotten rid of local funding of schools, but there are states, you see that this disparity has been reduced, right? There are states that have attempted, sometimes because courts have ordered them to attempt, that have attempted to reduce the disparities by increasing state funding, which is distributed more equitably. So the local governments can still add to the budgets, but we're going to give more funding to all the districts. Occasionally, even, states are like, we're going to give some extra state money to the poorest districts. They need it the most. The costs are higher there. Right? In the Syracuse City schools, they got to provide so much in the way of social services, right? Free breakfast and lunch, right, to their kids, in addition to just ordinary instruction, right? It costs them. You should, in some kind of rational world, you should be spending more money to educate poor kids than rich kids, not less. But so the states have sometimes tried to equalize it. No state in the country has gotten it all the way equal. No state in the country has gotten rid of local funding. But they've reduced the disparity. Some states have. Yeah.
It's kind of a stretch, but I feel like it's possible if we really, really looked into it to make the Commerce Clause part of it.
How's that?
Because they're talking about taxes, it's going to impact the way people buy things.
Mm-hmm.
You'd have to really look into the numbers and really make an argument, but I feel like you could.
So this is partly responsive. So prior to the 1960s, the federal government spent very little money on education, right? And as part of LBJ's war on poverty and everything else, right, we're passing civil rights laws, we're passing Medicaid, right? All these efforts to help have the federal government do more to address the issue of poverty throughout the country. One major law that's passed during the 60s is called the Elementary and Secondary Education Act, which is the first major federal intervention into public schooling, and it came with lots of new federal money, right? And the federal money has the effect of reducing these disparities, not eliminating, but reducing them. And that federal law enacted by Congress could be justified on the basis of the Commerce Clause. But I don't think the Commerce Clause, right? The Commerce Clause is something that gives power to Congress. In the absence of Congress, if you're the lawyer's office and I'm the poor family and I'm walking into your office, what can we do about this? Right? You could say, well, under the Commerce Clause, Congress has the authority to give more funding to school districts. You could call your congressman. But I don't think it helps the court directly address this inequality, right? It would help Congress do it, and it would help the court uphold Congress's effort, but it doesn't help the court do anything directly. Right? Let me come back to the point here about the state constitution. Raise your hand if your group had any discussion of whether there is a constitutional right to an education of some kind. Did that come up? All right, and where did you wind up on that?
Additional information.
We need additional information, right? Yeah.
So in the Constitution, it's not enumerated, so there is no constitutional right to education.
There is no enumerated constitutional right. Can anybody think of a constitutional right that the court sometimes protects, even though it is not mentioned in the Constitution? Yeah. Yeah. How about that one? We are going to read a case in which Connecticut banned the sale or possession of contraceptives. And the Supreme Court struck that down on the basis of a constitutional right to privacy. which is not mentioned in the constitutional text. So the fact that something is not mentioned in the constitutional text does not necessarily mean there is no argument for it. The court's argument in that case, Griswold versus Connecticut, is that the word liberty in the 14th Amendment, no state shall deprive any person of life, liberty, or property without due process of law. That word liberty is a broad abstract guarantee of a variety of fundamental rights which are not listed in writing anywhere, and one of them is the right to privacy. You could make the case that education is a fundamental right, too. Right? Two different ways to think about the issue here, right? Governments are spending substantially more money to educate rich kids than poor kids. That's just a fact. It's still true today. It was even more true in the 1960s, right? Our government spends substantially more money to educate rich kids than poor kids. Is that constitutional or not? One way to think of it is this a deprivation of some fundamental constitutional liberty? Not one that is explicitly guaranteed in the Constitution, but think about the court's whole history of protecting liberty of contract and privacy rights and parental rights. Remember the cases from Con Law 1 where the court struck down a law making it illegal to teach anybody to speak German, an anti-immigrant law passed in Nebraska, right? The court struck that down. There is no, because they said parents should be able to teach their kids to speak whatever language they want. That is not in the Constitution, and the court struck it down in the 1920s, right? So the court sometimes says, and remember the Ninth Amendment, which appears to say explicitly that there are unenumerated rights. The court sometimes says there's a constitutional right, even though it's not expressly guaranteed. A different way to think about the same issue is not that it's so much violates somebody's specific right, whether or not it's in the constitutional text, but that it's discriminatory. Right? So education is something important that's provided by the government, and like maybe the government's not required to provide education at all, but if it does provide education, it can't do it in a discriminatory way. And one way that this might be potentially discriminatory is as an indirect form of racial discrimination. If I gave you the same facts but left out the race part, both of these districts are all white, is that still discriminatory in any way? Yeah.
Maybe based on class.
Yeah, that's another possibility. There are lots of poor white school districts that are dramatically underfunded too. Why isn't that discriminatory? Right? So you might argue, even if these districts are both white, or even if we all kind of know that this majority Mexican-American district, part of the reason they're underfunding it is because of anti-Latino racism. We know that, but we don't actually have any evidence, right? They didn't do anything explicitly racist. We don't have any evidence. We might have suspicions about that. So let's leave the race part out for now because we can't prove it. We still think it's discriminatory because the government is providing more resources to rich families than poor families. Yeah.
See, that it makes sense if the government's making like an arbitrary choice to provide those funds, but like as stated before multiple times, the school districts are only providing funds to people that are in their district. They have no alternative but to provide their funds. It's hard to argue that there's some sort of discriminatory action happening within the districts themselves because they have no choice of who's in it.
So if you are on the school board in Jamesville, DeWitt, you do not really have lots of immediate options for how to improve education in the city of Syracuse, right? That's not part of your job, right? However, just to slightly reframe the question, right, if you are in charge of the New York State Board of Education, right, if you are the governor or the state legislature of New York State, you have made a conscious choice at some point in the state's history to authorize local governments to provide most funding for public schools with the clear expectation, everybody knew this would result, the clear expectation that would lead some local districts to have more resources available than others. Right? So if there's a discriminatory thing happening, it's not really by the local school districts, it's by the state. Right? The question is, can the state, under the 14th Amendment, which guarantees equal protection, can the state continue operating a system of public schools in which some school districts are allowed to spend 50% more money on their kids than a neighboring district? Brian?
Did they decide the gerrymandering case?
Did who decide
Supreme Court.
which gerrymandering case?
It's the one that you've been talking about.
The current one? No, that has not been decided yet.
Yeah, I was going to say, no, it's just if they decided you could maybe use some of their information or decisions from that case.
So it is possible that in some states you'd have actual clear historical evidence that, look, the state allowed this all-white, rich suburb to carve itself out of the LA County School District, right? That districting decision itself violated the 14th Amendment. You would have that in some states, but not everywhere, right? Some states, the boundaries of the local school districts go back for 100 years or whatever, and we don't have any evidence, they didn't let any Mexicans go to school back then, and that's just where they drew the boundaries, and just over time, it's led to these racial and class disparities. So sometimes you could look at the actual drawing of the lines, but sometimes you couldn't. So in the 1960s and 70s, lawyers made all of these arguments in a variety of contexts, one of which is school funding. And these arguments were successful in some kinds of cases and unsuccessful in other kinds of cases. The fundamental decision that's most directly relevant to what we've just been talking about is San Antonio versus Rodriguez in 1973, which was unsuccessful, 5-4. The Supreme Court rejected these arguments and upheld this. These are the numbers from that case. Upheld this pattern of unequal funding in the state of Texas, 5-4. I'll come back to that case in a minute. Lawyers here were building on a wide variety of things that what lawyers do is they take existing legal decisions and they tried to build on them creatively. Right? Well, remember how the Supreme Court said X, you can't do that? Well, isn't that kind of like this? I bet we could persuade them that you can't do this either. Right? Remember all the cases leading up to Brown versus Board of Education? First they said Missouri can't provide a white law school, and then no law school at all for African Americans. That is not even separate but equal. What is that? There's nowhere for African Americans to go to law school in the state of Missouri. You can't do that. And then the state of Oklahoma says, okay, we can't do that anymore, so we're going to let African Americans, first state of Texas says, we're not going to let African Americans into UT. We're going to create our own brand new law school for African Americans that doesn't really have any money or teachers or books or anything else. Operates out of the basement of the state capitol. Supreme Court says, nope, you can't do that. Oklahoma then says, okay, we're going to let African Americans attend the University of Oklahoma, but we're going to segregate them in each classroom. Right? There's like a rope marking off a corner of each classroom at the University of Oklahoma. That's where the black college students sit. The Supreme Court said, no, you can't do that either. Right? And this is all just about like law students and graduate students and college students. They haven't even gotten to public schools yet. And then eventually they get to Brown versus Board of Education. So that's what lawyers do. They build on particular things that the courts have said, and they try to creatively extend those. Well, if that's the principle that the Constitution requires, here's something else we got to look at. And during the 1960s, lawyers were trying to do this with a wide variety of laws that, from different angles, either discriminate against the poor, is one way to think about these laws, or deny certain fundamental rights to some groups of people, partly on the basis of how much money they have. Right? Let me give you some examples. We've actually already talked about one of these examples. In Harper versus Virginia State Board of Elections, the Supreme Court struck down poll taxes. Well, what the heck is that? What's wrong with a poll tax? Why can't we charge people $2 a year in order to have the privilege of voting? We've been doing it for 100 years. The reason we can't do it is, two ways to think of it. It is discrimination against the poor. Some people can afford to pay the $2 and some people can't. Or it is a deprivation of a fundamental right to vote. Another fundamental right, which, by the way, is not expressly guaranteed in the constitutional text. says you can't deny the right to vote on account of gender. Sex is what it says. You can't deny the right to vote on account of sex or race. Those two provisions are in the constitutional text. Besides those, nothing guarantees your right to vote in the constitutional text. But the Supreme Court says, yeah, but it's still clearly a fundamental right. Obviously, it's fundamental to our basic democratic system. You can't arbitrarily take it away from some people. And to take it away by charging people to vote, it's obviously predictable which folks are going to be losing the right in that instance. Not rich people. They're going to be fine. Right? To jump back even earlier, in a case in 1941 called Edwards versus California, Supreme Court struck down a state law from California that made it illegal to bring a poor person into the state. What the heck is that? Why'd they do that? California passed a law that said it's illegal to bring a poor person into the state.
They did it in response to like the Dust Bowl and all of the farmers coming in like from Oklahoma and everywhere.
Grapes of wrath, right? Dust Bowl, drought across the whole middle part of the country, poor farmers in Oklahoma and elsewhere losing their farms. They can find some kind of beat-up old car. At least that's how it is in the novel and the movie, right? They get some kind of beat-up old car and make their way to California. And there are sometimes folks who would drive through Oklahoma with a truck offering rides. Pay me and I'll bring you to California. California doesn't want any more of these folks. It's illegal to bring a poor person into our state. The Supreme Court strikes that down. What are you doing? You can't do that. Right? Is this one country or is this not one country? Right? Again, there's two different ways to think of what's going on here. Is Edwards versus California about, like, a right to travel throughout the country? That is sort of what it's about. Is there a right to travel expressly mentioned in the constitutional text? No. But do you think that we have some kind of fundamental right to travel from one state to another? That seems kind of like an important right. So it's partly about a fundamental right that's being denied to some people, and it is partly about a form of discrimination. It doesn't say it's illegal to bring anybody into the state. It says it's illegal to bring poor people in the state. Right? The word that they used was indigent. Right? It is illegal to bring an indigent person in the state on the theory that then this person's going to rely on state services that the state's going to have to pay for, and we don't want to do that. Right? That's in 1941. In 1956, in a case called Griffin versus Illinois, Supreme Court said that you cannot charge somebody a fee in order to appeal his criminal conviction. Right? State and local courts often had a practice that if you got convicted of a crime and then you wanted to appeal, there was a cost you had to pay. Right? An actual cost that the court has to incur. Right? We have to copy the whole trial transcript and send it up to the appellate court. We don't want to pay for that. You got to pay for that. Right? That is not a problem for people with money, but for people without any money, oh, sorry, I do not have those $15. The court is like, all right, you are not allowed to appeal your criminal conviction. Supreme Court strikes that down. You can't do that. And again, is this about discrimination or is it about a fundamental right? It's kind of both. Right? If you get convicted of a crime, should you have some fundamental right to appeal that conviction to a higher court? That seems important. And is the court making something available to people in different amounts based on how much wealth they have? Yes, it's also doing that. In Bodie versus Connecticut in 1971, similar case about divorce law. I think I forgot to write that one on the handout. Bodie versus Connecticut. In 1971, you had to pay a fee in Connecticut to get divorced. And if you could not afford the fee, you could not get divorced. Supreme Court says, come on. What? You're going to make these people stay married in the state of Connecticut because they are too poor to pay these court costs? You can't do that. Is there a fundamental right to get divorced in the constitutional text? No. But does it seem like a pretty important right? If you've got a fundamental right to get married, also not in the constitutional text, but Supreme Court has some cases on that front. I'm pretty sure you should have the same fundamental right to end the marriage. Right? So it's partly about guaranteeing an implicit, unwritten, fundamental right. And it is partly about preventing discrimination against the poor. Rich people were getting divorced just fine in Connecticut. Right? Folks who couldn't afford the fee were not allowed to get divorced. Building on all these decisions, some lawyers who sometimes called themselves welfare rights lawyers, there was a movement during the 1960s that sometimes called itself the welfare rights movement. Some lawyers began to argue that there were certain forms of fundamental necessities of life that the government was constitutionally required to make available to people. Right? Maybe education is an example. Right? You cannot be successful in this country without education. If we're not providing a fair and adequate education to some people, that's fundamentally unconstitutional. But maybe there are other fundamental necessities. Shelter, food, and maybe the government is required to provide some minimal level of those to folks as well. And again, there's two slightly different ways to frame the argument. Is it that everybody has a fundamental right to adequate food? Or is it that the government is adopting policies which are discriminatorily providing certain groups of folks of adequate food? Right? Two slightly different frames on the question, but either way, an effort to persuade the courts to mandate some degree, some minimum standards of government provision for the poor. I'll give you a couple examples. In a case called King versus Smith in 1968, so the major federal welfare program at the time was called Aid to Families with Dependent Children, AFDC. This program doesn't exist anymore in the same form, but it dated to the 1930s, right? Passed under FDR. Aid to Families with Dependent Children. And the logic of the program was to provide federal financial support to families with school-age children that lacked a male breadwinner, right? So single moms. That's how the program was created from the start, right? There's a single mom. There's no breadwinner in the house. So the government's going to provide some minimal degree of support to help them cover rent and food and the like. King versus Smith came from Dallas County, Alabama. And in Alabama and 17 other states at the time, a caseworker, right? So if you were getting welfare benefits, you'd get assigned a social worker, right, who works for the government, who would be in charge of managing your case and ensuring that you are eligible for these benefits and the like. A caseworker could cut off your AFDC payments if she determined that a so-called substitute father sometimes cohabited with the children's mother. Right? Is there a man living here? Well, why isn't he buying the food? No more welfare payments for you. Right? Happened all the time. In Dallas County, Alabama, from 1964 to 1967, 184 families had their benefits cut off under this provision. 182 of them were African American. I don't think that's because there's no cohabiting men in white single mom households. Supreme Court says this is unconstitutional. Right? Well, wait a minute. The government is providing financial support to certain categories of poor families, but it is taking it away with no hearing, by the way. The caseworker would just say, you're cut off. No hearing of any kind. Right? You're cut off. We see evidence that a man is living here. Right? Court's like, come on. Now, are we saying that the government is required to provide financial support to poor families under the Constitution? No, we have never said that, and we're not quite saying that today. But if the government does provide it, are there some minimal kind of standards of fairness and equal treatment that the government has to follow? Supreme Court says yes. Following year, a case called Shapiro versus Thompson. Connecticut had a law. This is not quite as bad as the anti-Okie law from California in the 1940s, but you can see the parallel. Connecticut had a law that said if you just move to Connecticut, you have to wait a year before you are eligible for any kind of welfare benefits. Right. So this policy, like many social welfare policies in the United States, this policy is a federal policy. It's a law enacted by Congress, and the money mostly comes from Congress. But most of the rules are set at the state level, which in a way is a weird thing to do, but that's how we've done things a lot in U.S. history, right? But different states got their own different circumstances. Federal government's going to provide the money, but states going to decide how to use it, right? There's some minimal federal rules, but states get to set the detailed rules. Connecticut says you got to wait a year. Poor person moves into the state from Oklahoma or anywhere else. Got to wait a year before they're eligible for any welfare benefits. Supreme Court strikes that down. And it is not crystal clear what provision of the Constitution that violates. And the Supreme Court, citing the anti-Okie case from the 1940s, says partly this is about a right to travel. Everybody's got a right to move. You're an American, you got a right to move to Connecticut if you want to move to Connecticut. Connecticut can't try to keep people out. Right? It's partly about a right to travel. And it's partly, the court seems to be like edging towards the idea that there's some fundamental minimal level of services that the government has to provide to folks. Right? We're talking about cutting off payments such as AFDC, which are designed to help unemployed single mothers feed their children. No, you don't get those payments for a year. Come on. Like, does the government have an obligation to these families or not? The court seems to be saying there is some degree of obligation here. Right? Piece by piece. One little step at a time. There's not like a right to welfare, but there's the right to some degree of fair treatment at the time. Fair treatment of poor folks by the government. And it's all of these kinds of cases that the lawyers try to build on in San Antonio versus Rodriguez. They're like, just like voting rights and the right to appeal your criminal conviction, those are fundamental rights. Education is a fundamental right too. The government, I know it's not explicitly in the constitutional text, but the government has some kind of obligation to provide education to everybody. Right? And they're not providing an adequate education in the Edgewood Independent School District. Or, if you don't like that argument, and lawyers do this all the time, right? My client wasn't even there. It was self-defense, right? Like, one of these is going to stick, right? Lawyers do this all the time, right? Or if you don't like that argument, you're not persuaded that education is a fundamental right. The Equal Protection Clause of the 14th Amendment prohibits laws that discriminate against the poor. Laws that discriminate on the basis of economic class. Right? They make both of those arguments in the San Antonio case. And they lose on both of them. 5-4. San Antonio versus Rodriguez is in 1973. So we are jumping forward slightly in time. The court that decides San Antonio versus Rodriguez includes 4 judges who are appointed by President Nixon, right, who was elected in 1968. Earl Warren is not there anymore. This is a different Supreme Court, one which we will spend a lot of time talking about. This is like a preview. The Warren Court, up through 1969, seemed to be moving in the direction of requiring some greater degree of fair and equal governmental treatment of the poor as a constitutional requirement. Right? There's all these individual cases that kind of one step at a time move in that direction. And many folks, were optimistic that the court was going to do something about inequitable patterns of school funding. But by 1973, the court is shifting in a different direction, and it backs away from that. 5-4. I'm starting to go. Questions about that so far? Yeah.
Were all 4 of the Nixon appointees in that 5, or did they themselves appoint?
That's a good question. Let me see if I can remember. Powell, who's a Nixon appointee, wrote the opinion. He wrote the majority opinion. Powell, Rehnquist, Berger. I'm pretty sure all four of them are in the majority. We can look that up. I'm pretty sure that's right. Yeah, check.
So, did the lawyers bother citing some of these opinions to the court?
They did. Yeah.
It seems like really, I don't know, crazy that they can go so 180 just from a few appointments, especially because the position's supposed to be based on previous cases, and the previous cases seem to follow the track that this would be ruled unconstitutional, almost guaranteed. But.
So one of the themes that we will see more than once this semester, I'm going to give you two different angles on this theme. Angle one, Supreme Court follows the election returns, right? If the country moves in a more conservative direction, starts electing more conservative presidents and senators, they start appointing more conservative Supreme Court justices, the court moves in a conservative direction, and it starts changing its mind about a bunch of constitutional issues. Or same thing in reverse, right? This, at the moment, we're talking about 68 election, moving in the conservative direction. That's one angle. And so there are lots of examples we are going to look at in which the court of the 70s and 80s and since, right, the court that was built by Presidents Nixon and Reagan and the two George W. Bushes, that court moved in a more conservative direction. A different angle on the same issue. The court does not work just like the rest of political institutions. It's not actually true that the judges do everything just blatantly, politically, and ideologically. That is not true, right? And we are going to see multiple examples in which landmark liberal decisions from the Warren Court era get upheld over and over again by more conservative justices later on. So there are examples of both, right? Sometimes the court does what you were suggesting it should do. Sometimes the court's like, oh, well, that case from 10 years ago, I don't know if I would have decided it that way, but that's the precedent that's set, and we're supposed to follow that ordinarily. And there are lots of examples of the court doing that. Sometimes the court decides to move in a new direction. And when there are a whole bunch of justices appointed in a short period, Nixon appoints 4 justices in a relatively short period of time, probably increases the chances that the court's going to veer in a different direction. So one thing that's going on here is a political story about partisan, political, ideological shifts influencing the Supreme Court. There's also a legal story going on here. If you read, we got time for this? Yeah. Read the first paragraph on the top of your handout. The first half of that quote from Justice Stewart. This is from another welfare rights case that I haven't told you about yet. So Dandridge versus Williams, it's another AFDC case. So remember, aid to families with dependent children, government aid for single moms. And one of the features of this program is that it was explicitly designed to provide support for the children, right? The way that the funding levels were established was based on trying to assess some kind of subsistence needs of children, right? It was not designed to support the grown-ups in the house. It was designed to support the children. And so larger families would get a larger check, right? A family of 5 would have more subsistence needs than a family of 2. But some states set a cap, right? So each additional kid would be this much additional dollars per month, but it's capped at 5 kids or whatever it is. And a mom with more children than that challenged that as unconstitutional. She said, the government policy says explicitly that this is designed to meet the subsistence needs of poor children, and it says explicitly, here's our estimate of the bare minimum poverty level subsistence needs of a child, and you multiply that times 5, you get this much, but I got 7 kids, and the government is paying for 5 kids. Right? They are explicitly not doing what the policy says is necessary. Violates the Constitution. She loses. And Stewart writes the majority opinion. What is he talking about in that first paragraph? Can you make any sense of that? Yeah.
Well, I think one of the things he's trying to say goes back to last semester where he's saying it's not the court's job to strike down stupid laws, only unconstitutional laws. It's up to the legislator to fix the bad laws.
Yeah, and what kind of laws in particular? Like, so stupid laws, but what kind of stupid laws?
Oh, well, he says unwise, improvident, or out of harmony.
Sure, in what kind of area of regulation?
Racial?
No. What's he say?
Social and economic.
Yeah, social and economic regulation, right? Here we deal with state regulation in the social and economic field that does not affect any freedoms guaranteed by the Bill of Rights. There's no explicit provision in the Bill of Rights that's at issue here. Nobody's free speech or freedom of religion is violated. For this court to approve the invalidation of state economic or social regulation as overreaching would be too reminiscent of an era when the court thought the 14th Amendment gave it power to strike down state laws because they may be unwise, improvident, or out of harmony with a particular school of thought. That era long ago passed into history. When did it pass into history? It passed into history in the spring of 1937, when the Supreme Court, in response to FDR's court packing plan, reversed course and all of a sudden stopped striking down economic regulations that it had been regularly striking down previously throughout its entire history, but especially in the late 20s and early 1930s. Remember, the court striking down child labor regulations, court striking down minimum wage laws, court striking down maximum hours laws, over and over and over again. We used to, this is what Justice Stewart says, we used to spend a lot of time second-guessing Congress's judgments about economic regulations. Well, does that interfere with somebody's liberty of contract? Is that one too arbitrary? We're going to strike it down. We stopped doing that a long time ago. And the lawyers here are trying to persuade us to do that again. Right? A welfare law is basically an economic regulation. That's true from one angle. The welfare law is an economic regulation of sorts. People's elected representatives in Congress and the state legislatures get to decide, for the most part, what kind of economic regulations they want to have. Courts are not going to second guess that. Justice Marshall, Thurgood Marshall, civil rights hero, Thurgood Marshall, right? He's a great NAACP lawyer, litigated Brown versus Board of Education and multiple other cases. He litigated like 20-some cases to the Supreme Court, and he won almost all of them. And LBJ appointed him to the Supreme Court in 1967. Thurgood Marshall writes a dissenting opinion, and he's like, come on. We're not talking about a regulation of milk products, right? Remember Caroline Products? We're not talking about what's the best, most appropriate regulation for adulterated milk products, right? They were filling the milk by adding some other white liquid to it to make it cheaper to produce. Right? And Congress was trying to regulate it. We're not talking about second-guessing regulations of businesses like that. I'm with you. Okay, leave that to Congress. We don't got to jump in on those. That's not what we're talking about here. We are talking about governmental policies that affect the fundamental necessities of life for poor families. I don't think the same constitutional rules should apply as applies to how do we treat governmental regulations of the milk company. Right? Those are they both have something to do with economics? Yeah, okay. Right? But they are two completely different kinds of things. the vision of the Equal Protection Clause. The vision of the Equal Protection Clause that the court is developing during this period, which we will talk more about, but I want to introduce it, is that I think the clearest way to think about this is remember the categorical approach to freedom of speech. Right? Supreme Court says over and over again, although sometimes eventually abandon this, but for a while, Supreme Court said over and over again, there's some categories of speech that are constitutionally protected under the First Amendment and some categories that aren't. So if we have a regulation of political speech, we're going to look at that super closely, and there's a good chance we're going to strike it down, right? We're going to scrutinize it really closely, and the government's going to have an awfully good reason, I don't know, maybe some kind of national security thing, sometimes justify it, but they're going to have an awfully good reason. But if they're just regulating, obscene magazines, that's unprotected speech. That's not what the First Amendment is about. Maybe we'll take a quick look to make sure the government's not doing something totally crazy, right? Just regulating obscene Republican magazines, right, and not obscene Democratic magazines or something, right? We'll take a quick look at it, but we're not going to scrutinize it very closely because mostly that's not what the First Amendment is about, right? Two separate categories of activity. They do something similar with the Equal Protection Clause, right? Some of the justices during this period start to say the 14th Amendment Equal Protection Clause was about one main thing. It was about preventing racial discrimination. And so anytime we see a law that directly discriminates on the basis of race, we are going to look at that super closely. We are going to scrutinize it really hard. And we are probably going to strike it down. Because unless the government has some really good reason to be discriminating on the basis of race, that is probably unconstitutional. But there are other kinds of laws that treat two different groups of people differently on the basis of something other than race. Those are not really what the Equal Protection Clause is about. Right? This school district gets this amount of money, this school district gets this amount of money. Right? That's not discrimination on the basis of race. Maybe it's discrimination on the basis of wealth. Maybe that has some overlap, some correlation with racial patterns in that community, but it's not discrimination directly on the basis of race. Right? Some laws discriminate on the basis of race. Those are fundamentally suspect under the 14th Amendment. By the way, of course, for most of the 14th Amendment's history, the court wasn't even doing anything about those laws. But now we are. Now we're doing something about those laws. We're focused on it. We're getting rid of laws that discriminate on the basis of race. But laws that discriminate on some other basis, that's not really what the 14th Amendment is about. And these laws that we're talking about here, right, differential patterns of school funding or differential levels of welfare funding for different family types, they might have some correlation with race, but they are not discriminating on the basis of race. And so we are not going to worry about them that much. We are going to provide the same degree of judicial scrutiny to these laws that we apply to regulations of for-profit businesses, where mostly we say Congress can enact whatever regulations it thinks are the best regulations. Right? Congress can enact whatever welfare requirements it thinks are the best welfare requirements. State legislatures can enact whatever school funding processes it thinks are the best school funding processes, as long as they are not discriminating on the basis of race. Explicitly discriminating on the basis of race. Right? That's what the court starts to say in the early 1970s, which raises some significant questions about what are we going to do about gender discrimination, for example? Where does that go? And then as you move forward in time, discrimination on the basis of sexual orientation, gender identity, immigration status, disability, variety of other forms of discrimination that one might think of. But at the time, they haven't answered those questions yet. At the time, they're saying there's basically two categories. Does the law discriminate on the basis of race? Okay, highly suspect, probably unconstitutional. Does the law discriminate on the basis of something else? All right, we'll let the legislature do what they want. That's what they're saying in the 1973 case. And we'll pick back up with this next week.